Have you ever felt just completely lost, trying to make sense of a super long contract? Or maybe you've been stuck with something faulty and getting your money back felt, well, impossible.
Oh, absolutely. It's so frustrating.
Right. And that feeling like you're powerless against a big company, that's exactly why we have the Consumer Protection Act, the CPA.
Exactly. That's what it's all about.
And that's our focus today on the deep dive. We're going to cut through the confusion and hand you a really powerful tool. The Consumer Protection Act 68 of 2008. Honestly, if you buy anything goods, services, which is, let's face it, everyone, this is your shortcut to knowing your rights. We'll unpack it clearly, look at some surprising bits, and give you practical takeaways. And for anyone studying law, this should really deepen your understanding of its purpose, the legal background, and just how significant it is in the real world.
Yeah, that's a really important point. This act, it was signed back on April 24, 2009, mostly kicked in April 2010, but the full start date was actually pushed to March 31st, 2011. And it wasn't just a tweak, it was a major overhaul. It pulled together a bunch of older laws like the Merchandise Marks Act, Price Control Act, stuff like that.
Consolidation.
Right. It basically modernized the whole landscape of consumer protection in South Africa, creating one strong framework.
Gotcha. So let's start right at the beginning, the foundation. I hear the preamble itself sets quite a tone, acknowledging South Africa's history.
It really does. It's quite powerful, actually. It explicitly talks about fulfilling the rights of historically disadvantaged people, making sure they can fully participate as consumers.
Okay.
And it also aims to bring South African law in line with international consumer rights standards. So it's not just about the transaction itself, it's broader. It touches on social justice, economic inclusion.
That really frames it differently, doesn't it? It's not just about, a faulty toaster.
Yeah.
So what are the main goals then? What's it trying to achieve day to day?
Well, the big picture is to create a marketplace that's described as fair, accessible, efficient, sustainable, and responsible. That's the ideal.
Yeah.
And a really key part is reducing the disadvantages faced by vulnerable consumers. The Act actually lists them. Low-income people, folks in remote areas, minors, seniors, people with low literacy or vision impairment, or even just limited fluency in the language of the deal.
Wow, that's specific.
Yeah, it's very intentional. This proactive protection for those who might be easily taken advantage of is a really defining feature.
So it's actively trying to level that playing field. What else is it aiming for?
Well, it's pushing for fair business practices across the board, protecting consumers from unconscionable conduct that means stuff that's just grossly unfair.
Okay.
And also protecting against deceptive, misleading, unfair, or fraudulent actions. It's pretty comprehensive.
Yeah.
And ultimately, it's also about boosting consumer awareness, encouraging us all to make responsible choices, and crucially, providing clear, accessible ways to sort out disputes.
Empowerment, really.
Exactly. Knowing your rights and having a way to enforce them.
That sounds incredibly thorough. Now, how does the law actually get interpreted? Because, the text is one thing, how it plays out in court is another.
That's a critical point. Section 2.1 basically says the act must be interpreted in a way that achieves its goals. So that pro-consumer spirit has to guide how judges read it.
Right.
And here's something really significant, legally speaking. If the CPA clashes with another law, Section 2.9 says the rule that gives the greater protection to the consumer wins out.
Whoa. Okay. That's huge.
It is. It clearly signals that consumer protection is the priority when laws conflict.
So the CPA usually comes out on top. What about those really dense contracts, the standard ones you get for phones or gyms? The ones nobody reads properly.
Yeah, the Act tackles that too. Section 4 says courts have to interpret any confusing bits or restrictions in those standard contracts in a way that benefits the consumer.
Really?
Yes. So if there's ambiguity, it swings your way. It basically puts the pressure on businesses to write clear, fair contracts that don't sneakily limit your rights. It's a big push for transparency.
Okay, that's good to know. Let's dive into the actual rights then, the core protections. You mentioned equality earlier. How does that work in practice?
Right. So Part A of Chapter 2 covers the right to equality. Section 8 essentially says suppliers can't unfairly discriminate. They can't exclude you, give others priority, offer different quality goods, or charge different prices based on grounds like race, gender, religion, the kinds of things protected in the Constitution.
Makes sense.
But Section 9 clarifies that some differential treatment is okay if it's reasonable, like refusing to sell alcohol to a minor, that's fine for safety. or offering discounts to seniors, say over 60s, that's allowed too.
So this is about unfair discrimination.
Precisely. It's about fairness, not necessarily identical treatment for absolutely everyone in every situation.
Okay, moving on to something that drives a lot of people crazy. Privacy and choice, especially all that direct marketing. Junk mail, cold calls.
Yes, Section 11.
Yeah.
This is a big practical one. You absolutely have the right to tell marketers to stop contacting you. You can refuse, demand they stop, or even preemptively block them.
Preemptively block. How?
Well, the Act actually talks about setting up a national preemptive block registry, like a do not contact list. Now, that specific registry part hasn't fully commenced yet. It needs to be established first. But even without it, you can directly tell any specific company to take you off their marketing list, and they have to comply.
Okay, that's empowering. People like hearing that. Now, what about fixed-term contracts, phone plans, gym memberships? They often feel like traps.
Right. Section 14. This is often an aha moment. You generally have the right to cancel a fixed-term agreement by giving 20 business days notice.
Even halfway through.
Yes, even midterm. Now, the supplier can charge you a reasonable cancellation penalty, but they can't just lock you in indefinitely.
Okay, a reasonable penalty.
Correct. And here's another key bit. At the end of the fixed term, unless you specifically tell them to cancel it or you agree to a new fixed term, the contract automatically continues on a month-to-month basis.
Oh, interesting. So it doesn't just stop.
Nope. It rolls over monthly. This prevents you suddenly losing service, but it means the onus is on you to actively terminate if you don't want it anymore after the initial term. Many people miss that.
Good to know. And the famous cooling off period. Does that apply broadly?
That's Section 16. It applies specifically to transactions that result from direct marketing. Think telemarketing, someone knocking on your door.
Yeah.
You get 5 business days after the transaction happens or after the goods are delivered, whichever is later, to cancel it. No reason needed, no penalty. It's your safety net against high-pressure sales tactics in those situations.
Okay, so specifically for direct marketing sales. Now, what about those really weird cases where you get stuff you never asked for, like a random parcel shows up?
Unsolicited goods. Section 21. This is one of the most surprising rights, I think. If a supplier leaves goods with you or performs a service without you asking for it or agreeing to pay for it, it's legally unsolicited.
And then what?
And then you can just keep it. The Act says you can retain the goods and ownership passes to you unconditionally.
For free. No obligation to pay.
0 obligation to pay. And you're also not responsible if the goods get lost or damaged unless you deliberately mess with them. It completely flips the script on companies sending unsolicited stuff. It's a huge risk for them.
Wow, okay. That is genuinely surprising. So beyond these kinds of privacy and choice issues, the Act really pushes for transparency too, right? Disclosure and information.
Absolutely. Section 22 is huge here. The requirement for plain language.
Plain language, what does that mean legally?
It means that notices, documents, contracts, they have to be written so that an ordinary consumer, someone with average literacy skills and not much experience with that type of transaction, can understand it without undue effort.
No more hiding behind complicated jargon.
Exactly. No more dense legalese designed to confuse. It's a massive shift toward empowering consumers, especially those who might have struggled with complex documents before.
That seems incredibly important. And what about just simple pricing, like on a shop shelf?
Covered too. Section 23 says retailers have to display a price. And here's the neat little rule. If you see 2 different prices displayed for the same item, the supplier has to honor the lower or lowest price shown.
Good to know for bargain hunting.
Well, there's a small exception for genuine, obvious mistakes that they correct and tell you about. But generally, if there's ambiguity in displayed prices, you get the benefit. It stops bait-and-switch pricing.
Right. And product labels, what does it say about those?
Section 24 deals with labeling and trade descriptions. Suppliers can't use misleading descriptions or tamper with labels. For certain types of goods, producers or importers have to disclose the country of origin, and crucially, if they contain genetically modified ingredients.
Okay, so transparency extends right down to the product itself.
Yeah.
What about the way things are marketed? Advertising, claims, and promotions.
That falls under fair and responsible marketing. Part E. Section 29 sets a general standard. No marketing that is misleading, fraudulent, or deceptive in any way. This includes false claims about what a product can do, its price, or whether it's even available.
And you mentioned bait marketing.
Yes, Section 30 tackles that specifically. A supplier can't advertise goods at a special price if they don't actually intend to sell them at that price, or if they don't have reasonable quantities available given the advertising. No luring customers in with deals that aren't real.
Makes sense. And what about negative option marketing? I think I know this one.
You probably do, and it's strictly forbidden under Section 31.
Yeah.
This is where a company says something like, we'll start sending you this magazine, and unless you tell us not to, we'll charge you.
Right.
That's completely banned. A supplier cannot make an agreement binding just because you didn't say no. Any agreement supposedly formed that way is void. You have to actively agree.
Thank goodness for that. No more sneaky subscriptions. What about competitions like win a car?
Section 36 covers promotional competitions. Key point. They can't require you to pay anything to enter, other than maybe reasonable postage or data costs to submit your entry.
So no buying tickets to enter a promotional draw.
Correct. The rules also have to be clear and available, and certain people connected to the promoter, like employees or their families, usually can't win.
Okay. Now let's move into fair and honest dealing. This sounds like it covers some potentially nasty tactics.
It does. Section 40 prohibits unconscionable conduct. This is quite broad. It includes using physical force, coercion, undue influence, pressure, harassment, or any really unfair tactics when selling, negotiating, or collecting payment.
So aggressive debt collectors, for example.
Potentially, yes. It also specifically says it's unconscionable to knowingly take advantage of someone's vulnerability, like a disability, illiteracy, ignorance, or inability to understand the language if they can't protect their own interests because of it.
That ties back to protecting vulnerable consumers.
Exactly. And Section 41 builds on this, prohibiting false, misleading, or deceptive representations in general. This covers things like falsely claiming affiliation, lying about a product's features like saying it's new, when it's actually reconditioned, or misrepresenting its availability or price benefits.
A whole range of dishonest claims.
Yes, and Section 43 specifically targets pyramid schemes and related scams. It prohibits participating in multiplication schemes, pyramid schemes where compensation comes mainly from recruiting others rather than actual sales, and chain letter schemes.
Good to see those explicitly outlawed. Now, a really big area for consumers: fair value, good quality, and safety. This is often where things go wrong after you've bought something.
Absolutely. Part H is crucial. Section 54 gives you rights regarding the quality of service. You're entitled to timely service, service performed in a quality manner, and importantly, the use of goods that are free of defects when used for that service. Think about a car repair. The parts used should be good quality.
Right, and the goods themselves.
Section 55 lays out the standards for goods. They must be reasonably suitable for their intended purpose. They must be of good quality, in good working order, free of defects, even hidden ones, and importantly, usable and durable for a reasonable period of time.
Reasonable period. That sounds a bit subjective.
It is, and it depends on the type of goods. You'd expect a fridge to last longer than, say, a cheap toy, but it sets a standard beyond just working out of the box.
Okay, and what happens if goods don't meet these standards? Say my new washing machine breaks after 3 months.
This brings us to Section 56, the implied warranty of quality. This is a cornerstone, right? For 6 months after delivery, if goods fail to meet those quality standards you mentioned, you, the consumer, have the right to return them, and the supplier must, it's not optional, do what you choose. Either repair the item, replace it, or refund you the full price you paid.
Wow, my choice. Repair, replace, or refund.
Your choice. And this applies even if the defect was latent, meaning it wasn't obvious when you bought it, but it was there. The responsibility lies with the supplier for those first 6 months.
That's a very strong protection. It puts the pressure squarely on them to sell decent stuff.
It really does. It shifts the power significantly compared to older buyer beware approaches.
Okay, so that covers faulty goods. But what if a product isn't just faulty, it's actually dangerous? It causes harm, like an exploding kettle or something.
Right. That's where Section 61 comes in. Liability for damage caused by goods. This is another game changer. It says that producers, importers, distributors, and retailers can all be held liable for harm caused by unsafe goods.
Harm meaning?
Harm includes death, personal injury, illness, physical damage to property, and any resulting economic loss.
And liable because?
Liable if the harm results from supplying unsafe goods, a product failure, a defect or hazard in the product, or even just inadequate instructions or warnings about potential risks.
Okay.
Here's the critical part. This liability applies regardless of negligence.
Regardless of negligence. So you don't have to prove they were careless.
Correct. It's what lawyers call strict liability. If the product was defective or unsafe and it caused harm, the entities in the supply chain are liable. You don't need to prove they messed up somewhere along the line. This makes it much easier for consumers to get compensation if they're harmed by a faulty product.
That is a massive protection. It covers the whole chain. So knowing all these rights is fantastic, but how do you actually make them happen? What if a supplier just refuses? Where do you go?
Great question. Enforcement is key. The Act establishes the National Consumer Commission, the NCC. It's an independent body set up to oversee the consumer market.
And what does the NCC do?
Its jobs include monitoring things, investigating potentially prohibited conduct, issuing notices if companies aren't complying, doing research, and importantly, promoting consumer education and awareness.
Okay, so they're the watchdog. But for me, the individual consumer with a problem.
Section 69 outlines your options for redress. You can potentially go directly to the National Consumer Tribunal in some cases, or you can refer your issue to an ombud scheme if one covers that industry, like banking or insurance ombuds.
Ombuds, right.
You could also go to a provincial consumer court if available. A very common route is to file a complaint directly with the National Consumer Commission, the NCC we just mentioned.
So you complain to the NCC?
Yes, under Section 71. And finally, you always have the option of approaching a regular court, although usually you'd need to try these other routes first if they're available.
So there's a definite pathway, multiple options. Does the system have, well, real teeth? Can companies face serious consequences for breaking these rules?
Oh, absolutely. The NCC can issue compliance notices, basically ordering a company to stop the prohibited conduct and take specific steps, maybe compensate consumers.
And if they ignore that?
Then things can escalate to the National Consumer Tribunal. And the tribunal, under Section 112, can impose some hefty administrative fines.
How hefty?
We're talking up to 10% of the company's annual turnover in the previous financial year, or 1 million rand, whichever amount is greater.
Wow, 10% of turnover. That's serious money for big companies.
It absolutely is. The tribunal looks at things like how bad the violation was, the loss suffered by consumers, the company's behavior, its size, and whether it cooperated. It's designed to be a real deterrent. Plus, certain actions, like obstructing an investigation or breaching confidence, can even be criminal offenses leading to fines or imprisonment.
Okay, so there are definitely consequences. Thinking about all this plain language, the 6-month warranty, strict liability, the fines, how does this actually change things for us just going about our daily lives?
I think the impact is pretty profound, even if we don't always think about the specific sections. That 6-month warranty, it means you have real power when that new gadget fails. You don't have to argue endlessly. The supplier has to offer a repair, replacement, or refund, your choice.
Right, that simplifies things.
The plain language rule means those confusing contracts should be getting clearer, making it harder for hidden traps. The unsolicited goods rule, it gives you confidence to just ignore or keep stuff you never ordered without worrying about a bill.
Yeah.
It fundamentally tries to level the playing field. It shifts power towards you, the consumer, making the marketplace fairer and more transparent. It's less buyer beware and more seller be fair.
It sounds like it encourages, or should encourage, better behavior from businesses too.
That's definitely part of the goal, fostering a culture of accountability.
And for our listeners maybe studying law, what's the bigger picture takeaway from the CTA?
Oh, for law students, it's a fantastic case study. You see how legislation can directly address social inequality, how statutory interpretation principles like favoring the consumer work in practice. You see the creation of a whole new redress system mixing ombuds, tribunals, and courts. And it clearly shows how statutory rights can overlay and sometimes override older common law principles, like moving towards strict liability in product safety cases. It's a really dynamic piece of legislation showing law evolving to protect people in a modern economy.
This has been incredibly insightful. This deep dive really highlights just how valuable the Consumer Protection Act is. It's not some abstract legal document. It's genuinely your shield, your tool in the everyday marketplace.
It really is. And understanding these rights is the first step. It empowers you to spot unfair practices, to question things, and importantly, to seek help if you need it. Don't hesitate to check out the resources from the National Consumer Commission.
Absolutely. Be aware, question things, know you have options. And as we wrap up this deep dive, here's something to chew on. Considering just how comprehensive this act is, imagine a marketplace where every single consumer truly understood and actively used these rights. How might that fundamentally change the way businesses operate and interact with us all every single day?
That's a powerful thought. It really could reshape things.
Definitely something to ponder. From the deep dive Thanks for tuning in, and we'll catch you on the next one.